Welcome to the Villar for Prosecutor podcast number 4. I'm Mike Villar. I'm a candidate for Allegan County Prosecuting Attorney, and with me today I have Kevin Travis, the supervisor of Watson Township. He wasn't able to make podcast number 3, so we're glad that he's back today. We also have producer James, who will be making comments as well as we go through the podcast. So welcome back, Kevin.
It's good to be back, and I will say producer James and you did a bang-up job exploring the Supreme Court oral arguments last time. But I'm glad to be back from vacation and ready to finish up this race.
Well, there's a lot of stuff to talk about today. We have a lot of things that are important things. And so buckle up because it's going to be fast and furious. The first thing we're going to talk about is an exchange that happened at a trial that I was in a couple weeks ago. And then at trial, it was a murder trial. And Myrene Koch was the lead attorney for the prosecutor, and Elizabeth Peterson, who's a judicial candidate, was the second chair. And there was an exchange during that trial that caused me great concern. As an avid supporter of the Second Amendment, a member of the NRA Golden Eagles, it made me very concerned. And so we're going to go through that a little bit, and we're going to read the transcript that I had prepared for what happened that time. Okay, so we're going to read through it. Elizabeth Peterson started saying, "Now, we talked a few moments ago about exhibit number 4, that green belt with that magazine clip. Did you observe any other magazine clips when you entered the residence?" And the deputy said, "Yes, ma'am." But Kevin, do you have any comments about magazine clips?
I do. I mean, first of all, the term magazine clips, it's not even a thing. I mean, that's just a term that
they misused.
That they misuse. It's indicative that she does not know what the hell she's talking about, because this is a magazine. It's removable. This is actually for an M1 carbine, and these are clips. These go into the legendary M1 Garand. The whole thing fits in there. This here is a stripper clip. In fact, this whole box was originally meant as stripper clips for the M14, which uses a box magazine, much like the G43 here, that could be reloaded with stripper clips into the removable box magazine. So, as a point of education, if you're going to be using terminology, make sure you have it right. And this is a rockin' luck. By holding my mouth just right. There we go. So first of all, I have a problem with just the terms that are used. I mean, if you're going to sound smart in court, make sure you're doing the right terms.
All right, let's go on. "How many did you see?" The deputy answered, Several for several different firearms. Ms. Peterson said, "Can you tell whether those magazine clips were loaded or unloaded?" Deputy answered, "Yes." "Which one was it?" "They were loaded ones." "Do you know how many?" "Off the top of my head, I do not." "Okay, and where were they in relation to that front entry or the green belt that you located on the freezer?" So that at that point, I objected. I said, "Your Honor, I guess I'm going to object to the relevance of this. Unless they can connect these somehow to the crime," which by these I meant other guns, other magazines. I said, "I don't know how they're relevant to what happened here." Ms. Peterson, and this is the point that I think is very concerning. "Your Honor, I think it's relevant. How many magazine clips were ready to go? I think it goes to intent." Now, the only intent that was charged in this crime was my client's intent to murder. So she's basically saying that how many magazines you have in your house, or how many clips, or how many loaded guns in your house goes to intent. So Judge Bakker said, "I would agree, go ahead." I objected. "Your Honor, I guess I would say the intent has nothing to do with how many," and I used magazine clips because that's what they were using. "How many magazine clips that you have in your house, I don't know how that goes to intent for anything." And Judge Bakker said, "I understand the objection. It's overruled." So what's your impression of that exchange?
Well, based on that exchange, apparently I brought a lot of intent to murder with me today.
Yes, you did.
My experience with Judge Bakker is that when I clerked there, I brought in NRA magazines for the enjoyment of folks to read in Judge Cronin's
In the chambers.
in the Judge Cronin's chambers. And one day they mysteriously disappeared. I later learned that Judge Bakker confiscated them and threw them in the trash because she felt they were threatening.
So just the NRA magazines by themselves were threatening, not even a loaded magazine.
Correct. Correct.
Well, my concern is that if you're in your home and if you have the unfortunate situation where you have to use a gun to defend your home, the fact that you have a loaded gun in your house, from this prosecutor's stance, would be some at least evidence of an intent to murder someone.
Exactly. And I had this exchange recently with a local resident, and I told them about this case. And they said, well, what if I leave a baseball bat next to my front door and somebody breaks my house and I use a baseball bat to protect me and my family? Is leaving the baseball bat next to my door intent to murder? I would say, based on this logic, that is what Elizabeth Peterson and Myrene Koch would argue. So, is my bayonet, fully loaded, I guess? I mean, if I take it out of the scabbard, does that make it more loaded, I guess? I mean, if I had, does it look more scary now?
Well, the big question is, does it go to intent? I see you're carrying a sidearm as well. And does that go to intent? And I think that if you're a Second Amendment believer and you believe in your right to keep and bear arms, the fact that they make these statements are very concerning.
Exceedingly, yes. In these, Myrene is allegedly running as a Republican, despite all of her signs being blue. But clearly, she and her mentor, Judge Bakker, clearly have an anti-Second Amendment bias.
So we thought that was important enough to bring up and talk about in this podcast.
And I guess I will finally chime in a little bit here, but just as an observer, and for me, it's like I don't like to be political. Like, I'm very much anti-establishment in my viewpoints, and I feel like a lot of the people in the systems, especially when they're corrupted, there's always what they say and then what they do. And you can't listen to what people are saying when they're in these positions of power. You have to see what they're doing. Like, what are people doing in court? What avenues, strategies are they actually implementing that change how my constitutional rights are applied in life? So when I see things like this, especially like the next thing we're going to be getting into about her comments on the Supreme Court ruling in the Lowe case, it's like what people say and what people do. Look at what people do. That's what's important.
Well, I think in this case it was clear that what they said was strictly done to get a conviction, and they don't whether they believe it or not, I'm not sure. But that makes it even scarier, because they will say whatever they need to say to get a conviction. So they can say on the one hand in court, oh, how many magazines you have or how many loaded guns in you have in your house is indicative of an intent to murder. But then if they get on the campaign trail, they'll say, oh, I'm for gun rights. But what they do in court speaks worlds of difference.
Well, it definitely shows that they're not constitutional liberty, constitutional.
Yeah, they don't. Their focus is not the Constitution. Their focus is getting convictions. So that's a good segue into the next case we're going to talk about, People versus Daniel Lowe. This is a case that started off when I ran 4 years ago. I did a Freedom of Information Act request and asked for emails between Judge Bakker and Myrene Koch. And I also asked for text messages. I got emails that I got quite a few emails, but when I went through them, there was one in particular that stood out that actually looked like Judge Bakker was emailing the prosecutor during the case, actually when witnesses were on the stand. When I found out, then I checked to see when the trial date was, and in fact, those emails were happening right when the trial happened. I took those emails and I sent them I filed a grievance against Marge Bakker and against Myrene Koch. But I sent the emails to Daniel Lowe's attorney, appellate attorney. And he immediately filed for a new trial for Mr. Lowe. And Judge Baillargeons granted that based on the appearance of impropriety, that it looked so bad that a judge would be talking to a prosecutor about a case during the case that he granted a new trial. And so after that, the prosecutor appealed, and the Court of Appeals, I think, made one of the most ridiculous decisions I've ever seen. Kevin, you can talk about that if you want.
Yeah, where basically they said that all of these communications were somehow administrative and therefore not ethical, and Myrene Koch took that and ran with it and said, see, I acted ethically. I didn't do anything wrong. How dare you guys accuse me and another public official, Judge Bakker, of misconduct because we did nothing wrong. It was all administrative.
And we showed that video. We showed what she was saying in response to that 4 years ago. And we then, last week, or the last podcast, we showed the questioning from the justices, and we also showed the attorneys, and even her own attorney in the Supreme Court said that it was obviously it was unethical.
Yeah, she lied to her opponent, or to her
The public.
to the public and her followers. She lied.
Yep. And so, after the appeal overturned Judge Baillargeons' grant of a new trial, the Supreme Court they appealed for certiorari to the Supreme Court, and the Supreme Court agreed to hear the case of Daniel Lowe only, and they limited what they were going to look at to whether the misconduct of Judge Bakker entitled Daniel Lowe to a new trial. And last week we showed the oral arguments from the Supreme Court, and now the Supreme Court has come out with an opinion. And the opinion, just in a quick nutshell, said that Judge Bakker violated the canon of ethics, and it was clear violation, and it was so bad that she should have, on her own, recused herself from the trial. And so then they somehow, with quite a feat of mental gymnastics, said that even though she should have recused herself and she was acting unethically and should have been off the trial, somehow Daniel Lowe got a fair trial despite that. So we're going to go through this a little more carefully, but I want to put up what the take that my opponent has. She posted that the conviction was affirmed, People versus Lowe, by the Michigan Supreme Court with 3 exclamation points. The email communications did not violate the defendant's constitutional right to a fair trial. Further, the justices stated there was no evidence Prosecutor Koch shared any info with the trial prosecutor because it was clear that the trial strategy did not change from beginning to end. There was no miscarriage of justice. Both the Court of Appeals and now the Michigan Supreme Court have given the vindication I have waited nearly 4 years for. But the most important thing is justice, once again, for the victim in this case. My original thought about that is I don't know if she's intentionally misleading the public or if she actually believes that.
Well, I don't know how she could say that she was vindicated when clearly the opinion indicated that she violated the rules of professional conduct, her and Judge Bakker.
Yes.
Repeatedly. I think between Judge Bakker and Ms. Koch, I think their names were mentioned nearly 100 times.
I think that Judge Baker's name was mentioned 36 times, and Prosecutor Cook's name was mentioned 75 times, which is highly unusual in a Supreme Court opinion. They very rarely will use the trial judge's name or one of the litigants' names. Well, they'll use the litigants' names, but not the litigants' attorneys' names. So this was unusual. So we have...
Now, and before you go on, I also want to note that not once did they mention the name of the trial attorney that prosecuted the case.
Yep.
Because she did nothing wrong.
Yep. She was not a part of the...
She was not a part of the unethical behavior. Correct.
Yep. So I went through the Supreme Court opinion, which is 98 pages. You can go to the Michigan Supreme Court website, and you can actually read it for yourself. But I went through and highlighted portions of the opinion that dealt with what was going on. So we're going to go through some of this, and you can read for yourself, and you can see for yourself what happened. So the trial judge never notified defendant or defense counsel of the emails or their contents. It is clear that the trial judge's private exchange with the elected prosecutor violated the Michigan Judicial Code, of the Michigan Code of Judicial Conduct. So here, she had talked about, I guess I should just read it. Before the trial prosecutor finished questioning the trooper, the trial judge, Judge Margaret Bakker, emailed the elected prosecutor for Allegan County, Myrene Koch, stating, "This trooper didn't do a very good investigation. Don't they have detectives with MSP, which is Michigan State Police, anymore?" Meanwhile, the defendant's jury trial continued. Now, that says a lot right there. That shows that Judge Bakker, while on the bench, while listening to the trooper testifying, she actually was emailing the elected prosecutor. So during that time, could she have been paying attention to what was going on while she was emailing the prosecutor?
You know, in how the Supreme Court didn't find actual bias here, because I think
It's amazing. We're going to get into that.
Yeah.
But Kevin, you were a law clerk,
yes,
and you law clerk for Kevin Cronin.
yes,
I was a law clerk for Judge Corsilia. I would never, ever in a million years believed you if you told me that Judge Corsilia had emailed the prosecutor during a case. Something that would never have happened. And I've known Judge Cronin long enough to know that that's not anything that he would have ever done either.
no. In fact, he was very self-conscious of any sort of ex parte communications. Very conscious of it. Wanted me to be aware of it. Wanted me to be aware of who I emailed on his behalf.
Yep.
So as not to even make it look like I was communicating ex parte.
It's just like Justice Bernstein said in the oral arguments, I'm a simple man. It just should never happen.
Yes, correct.
So here, Detective Todd Workman was on the stand. He acknowledged that the victim had not been referred for a medical examination, which contravened or was against investigative protocol. The next morning, just before the second day of trial began, Prosecutor Koch responded to Judge Bakker's email asking about whether the Michigan State Police had detectives, and she replied, "They do, but not typically for CSCs. This trooper has been given additional personal training since this investigation." A few minutes later, Judge Bakker responded, "One more question. This victim was not referred for a medical. Do you know why?" Then she took the bench and the second day of trial began. 10 minutes into trial, Prosecutor Koch responded, "Yes, because the prior APA, which is Assistant Prosecuting Attorney, assigned to the case did not check that it was missed, nor did anyone else who touched the file. As a result, there will now be a checklist for CSCs and files." While the victim's older sister testified, now again, once again, while somebody is testifying, Judge Bakker replied, "I thought Safe Harbor would catch it." Safe Harbor is where they take victims and alleged victims of criminal sexual conduct. They conduct interviews with them, and so that's what Safe Harbor is. After trial adjourned for the day, Prosecutor Koch responded, "Unfortunately, no, the forensic interview is supposed to check for that before case review. But the list is often given to interns. I noticed it after the fact at case review, but by then, it was not clear if the victim had much support." So, and this is the lead opinion right now. Because the trial judge's ex parte communications with Prosecutor Koch were not made for the purposes of managing or executing a pending or impending proceeding, they violated Canon 3A4A.
And I'll just chime in and say, like, we showed the video last week where they said they were above reproach and did nothing wrong.
Yep.
And I think that pretty much puts
that to rest.
And also for Myrene Koch to say that the Supreme Court upheld the Court of Appeals opinion, that is complete crap. Because really what they did was they overruled the Court of Appeals with regard to saying, no, this was not ethical conduct. But at the end of the day,
they affirmed the conviction, but they overturned the portion that said it was administrative in nature and not a violation of the ethics rules.
And I would say there was a lot of disagreement to get to that affirming of the conviction piece.
Yes.
There's obviously not really, I would say, necessarily a settled issue.
It wasn't it seems like they're saying it was an unfair trial, but not unfair enough. it's kind of what it seemed like they
that's
said.
actually exactly. And I think that what my opponent is saying in her little statement was, hey, we found the exact line that you can walk up to and be unethical, but still affirm the conviction. That's really what she's saying. We now know how far we can go, and even if it's unethical, and even if the judge should have recused herself, they don't have to recuse themselves, and they'll still be found fair because the burden of proof on the Supreme Court issue was placed squarely on the defendant to show that it had an effect on the jury, or that the judge was actually biased, which you can never prove. A defendant can never prove that.
And I would say that should the U.S. Supreme Court take up this issue, and I understand that they issued petition to go to the U.S. Supreme Court at this point.
They haven't yet, but they're intending on it.
Okay. What I would say is that is probably where the burden is. That's probably going to be the focus of the U.S. Supreme Court's.
And we'll talk about that as we go through. Let's go back to the excerpts that we had. And let's go on down. Let's see, I don't know where you're at, James.
This was page 1. We made it to the bottom, and then this is page 2.
Okay, not only did the trial judge give Prosecutor Koch private access to her ear, considering the contents of her communication, one might reasonably question whether the trial judge was interested in seeing the prosecution succeed or seeing the defendant convicted. For that reason, the trial judge should have known that grounds for her disqualification might have existed under MCR 2.003, under Canon 3C. She should have raised the issue of her disqualification sua sponte, which means on her own. Nobody should have had to move for it. And she should have recused herself.
I think the one thing that is so alarming to me, and I guess this is something that could be discussed about burden as well, is how casually they communicated. Like, it made it seem like they talk like that all the time.
Well, that's the question. Is this the first time that they've ever communicated during a trial about the trial? Or is it just the first time they've been caught? I know when I filed my grievance, there was at least three other occasions where they were caught in ex parte communications. And Kevin, you have another case that you've discovered.
Correct, and that was the case of People versus Brimhall, where there was an email from Judge Bakker to Myrene Koch, and the subject line was trial, and the essence of it was, and this was the first day of a 2-day trial, is when that email was sent. Hey, your assistant prosecutor is doing a good job, but she has some fact problems. So basically, it's Judge Bakker relaying to this assistant prosecutor's boss that were tactical errors made on the first day of trial. Now, an astute defense attorney or even an astute ethical attorney would see, well, there's a possibility to change your trial strategy on the second day if you're made tactical errors on the first.
When I did my Freedom of Information Act request that gave me the information on Daniel Lowe, I also asked for the text messages between Judge Bakker and Myrene Koch. They denied that request because Myrene Koch's phone was personal. So here, everything that we've talked about so far are email communications that they did using county computers on county email. So we never have gotten any information about things that might have happened with their phones, their own personal phones, and they've never offered to show their phones to see how much communication is actually occurring or how much they communicate when they go out to lunch. So it's really kind of disturbing because every person who's in government knows that if you use a government computer, everything that you put on there is subject to FOIA and can be given to anybody at any time. So knowing that, they still did it. So here, the Supreme Court goes on and says, and talks about the case of Lilleberg, I think, or Liljeburg, I'm not sure how to say it.
I think it's Liljeburg.
Liljeburg.
But
And so they say, consider the risk of injustice to the parties in the particular case, the risk that the denial of relief will produce injustices in other cases, and the risk of undermining the public's confidence in the judicial process. Then they say, likewise, there's always some risk of undermining public confidence in the judicial process if a new trial is not granted when a judge for whom there was reason to question her partiality presided over the first. A judge is engaging in ex parte communication with the prosecution may no doubt undermine confidence in the impartiality of the court. The trial judge's ex parte communications with Prosecutor Koch might have caused one to reasonably question the trial judge's impartiality. Now, they refused to adopt the Lilleberg case and rationale. That's the Sixth Circuit federal court. So if he goes to a federal appeal, I think he has a much better chance of showing that it has affected the public confidence in the judiciary. But looking at what, and this is the lead opinion, this is not even a dissenting opinion, to consider what we just read in light of Myrene Koch saying that she feels vindicated after 4 years is hard for me to believe. Because what they are saying is that Myrene Koch's communication with Judge Bakker was so wrong that it undermines public confidence in the judiciary. Myrene Koch, when I filed my grievance against her, one of the things that an attorney cannot do is assist a judge in violating the canon of ethics. And there's a specific rule of professional conduct. And in this case, when Judge Bakker instituted ex parte communication with her, meaning they didn't include the defendant or the defendant's attorney, every lawyer knows you don't have ex parte communications. And if you do, even if they're for administrative, you have to immediately tell the other side. So Myrene Koch would have known that you don't have those communications, and if you do, you have to immediately give them to the other side. And so she effectively assisted Judge Bakker in violating Canon 3A. And for her to say she feels vindicated by this opinion is mind-boggling.
Well, that's why in that first amicus, when I mentioned Brim Hall, I mentioned it in a footnote, and it was really a challenge to the Judicial Tenure Commission and to the Attorney Grievance Commission to actually do something about it. But I don't think they will.
Yeah.
And I wrote that to the Supreme Court as kind of like a throwdown, like, prove me wrong.
Yeah.
And it seems like she's got a little bit of a God complex at this point because she has not been punished.
No.
Although I will say that when I observed that Judge Bakker was added as one of the attorneys and parties into the caption of the Supreme Court case, I found that highly unusual because Judge Bakker had recused herself like 4 years ago when a new trial was first asked for.
Yep.
So for her to be added as a party
It was a little different.
was a little different. So when I got the email from the Supreme Court clerk, I was added, obviously, as the third person. So there was the defendant was party 1, prosecutor was party 2, Watson Township was party 3, and then the various other
Amicus parties.
amicus parties, and then Marge Baker was added as number 7, and there was no official
She
thing.
wasn't not an amicus party. She wasn't a defendant. She was just the trial judge who had recused herself 4 years ago.
Correct, and she was added, and then when Larry Royster, the Supreme Court clerk, sent out the email, there it was, her name, her email. So it was kind of like, oh, by the way, we're watching. That's kind of the impression I got.
I hope that's the case. Let's go back now. James, can you go back to the previous page? Because I think this is where the oh no, Justice Welch there. That's good. See, Justice Welch, this next excerpt is where Justice Welch, where she concurred in affirming the conviction, but dissented about what the burden of proof should be for a defendant. So let's go to the next page. So here she says, a judge who engages in unethical behavior is subject to investigation by the Judicial Tenure Commission and disciplinary action from this court. So far, I haven't seen any disciplinary action from the Supreme Court. A judge's unethical behavior on the bench can also undermine the integrity and public confidence in not only an individual trial, but also the judiciary as a whole. Unethical judicial behavior that taints the integrity of a criminal proceeding may require retrying or resentencing the accused. On this, the lead opinion and I are aligned. I concur in the lead's opinion conclusion that the email ex parte communications between Allegan County Circuit Judge Margaret Bakker and the elected Allegan County Prosecutor Myrene Koch during defendant's criminal trial were unethical and violative of the Michigan Code of Judicial Conduct and Michigan Court Rule 2.003, such that recusal was required. I conclude that the communications Judge Bakker initiated with Prosecutor Koch were substantive and of such a nature that a reasonable and objective person would question the judge's impartiality. Not only did the trial judge give Prosecutor Koch private access to her ear, which she cites the lead opinion, considering the contents of her communications, one might reasonably question whether the trial judge was interested in seeing the prosecution succeed or seeing defendant convicted. She goes on to say, not only is it a gross breach of the appearance of justice when the defendant's principal adversary is given private access to the ear of court, it is a dangerous procedure. An ex parte communication between a trial court and government counsel, in addition to raising questions of due process, which are constitutional questions, involves a breach of legal and judicial ethics. Regardless of the priority of the court's motives in such a case, the practice should be discouraged since it undermines confidence in the impartiality of the court. And I would say this, the actions of Judge Bakker and Myrene Koch have certainly affected the legal community's reputation in Allegan County. They undermine confidence in the impartiality of the court, and I would say that that's true in Allegan County of the general public, but I would also say it's true in Allegan County of the legal people, the legal system. There are attorneys in Allegan County and in surrounding counties that do not have confidence in the impartiality of the Allegan County Court.
And there's the one last excerpt as well. It says at worst, the ex parte communication is an invitation to proper influence, if not outright corruption. So they actually said that. And I think this rings true to what you were saying 4 years ago when you said corruption in Allegan County. And they literally there's the word. And they say, if not outright corruption, I think anyone who's incredibly familiar with the situation would say this is outright corruption.
That is what we said 4 years ago. There's a video on our Facebook page. You can go back and look at it. It had 30,000 views. We said it was corruption, and I think that we're the ones that should be saying we've been vindicated, not her.
Well, and if you take into account some former prosecutors that have witnessed the conversations that they had over at Mugshots, which is where they like to go to lunch, where they're actually discussing cases over lunch, even sentencings ex parte.
And that's been overheard, but the person who overheard it is afraid to say anything about it.
Yeah, and understandably, and that's where, why I did what I did, why the township allowed me to do that, because it needed to be done, because there's too much of the bar that is afraid of retaliation by Judge Bakker and Myrene Koch.
And I've experienced the retaliation. I mean, I have experienced it. So the emails commented directly on the police gathered evidence and police testimony, the very crux of the case, given the delayed disclosure and general lack of physical evidence in that case. Here, the trial court on remand may want to consider the secret nature of the communications in this matter and how the ex parte communications came to light by an unrelated third party filing a Freedom of Information Act request in 2020, which was me. And then it talks about you. Moreover, as the amicus brief filed by Watson Township suggests, the ex parte emails at issue in this case were not necessarily the only ex parte communications between Judge Bakker and Prosecutor Koch. Media reports also indicates that an ethics complaint has been filed against both Prosecutor Koch and Judge Bakker, but given the confidential nature of such complaints, until the relevant authority decides to initiate public disciplinary action, it's unclear whether these complaints have been investigated or whether disciplinary action would be pursued. At worst, ex parte communication is an invitation to improper influence, if not outright corruption. And we said that again. Whether the facts presented, the trial court on remand would need to consider whether the facts presented pose a great risk of undermining the public confidence in the judicial process and the impartiality of the judiciary. And I think that undoubtedly they would. They have to. There's no other way to look at it. So Justice Welch would say that we should do the Liljeburg test, which is what the Sixth Circuit Court of Appeals and the Sixth Circuit generally uses, and Michigan is in the Sixth Circuit. So if the case is appealed into the Sixth Circuit, they do have a different standard than we do.
And notably, that is the issue that the Supreme Court asked amici counsel and the parties to brief.
Yep.
So that was how that brief was written, in accordance with that Lillieberg test. Because obviously injustice happened in other cases, including Brimhall, in all the cases that you had uncovered as well, including a resentencing where she thought the resentencing was, quote, ridiculous.
Yep.
What actually is ridiculous is that the Supreme Court would think that somebody so unethical would sua sponte on their own, that's what that means in Latin, would set aside all of the prior corruption that they just had and say, oh, geez, maybe I should recuse myself from this trial because I'm actually biased. Well, it's malarkey.
The canon of judicial ethics really only works when judges are honest, when they are transparent, when they feel a bias, they would actually act on it. I've asked Judge Bakker to recuse herself 4 different times in 4 different cases, and she's never done it. And I don't think she ever will, because I don't think that as a matter of integrity, if she had that integrity, she would have recused herself in the Lowe case.
Exactly right.
So let's go on, because now we're down to the end of the opinion. This is Justice Bernstein. He's the one at trial who said, I'm a simple person. I just thought you just don't do it. And here he says, at worst, he signs the same Lopatin case. Ex parte communication is an invitation to improper influence, if not outright corruption. Oh, I'm sorry, I'm not reading Bernstein. Sorry, I'm going down. In closing arguments, the trial prosecutor addressed these deficiencies in more detail than she did in opening arguments. Now, if you go back to what Myrene Cook's statement was, that it didn't affect the trial at all. Like she said that there was no evidence Prosecutor Koch shared any information with the trial prosecutor because it was clear the trial strategy did not change from beginning to end. So we go back to what Justice Bernstein said, and he says, well, those deficiencies were addressed in more detail in the closing than she did in opening. And of course, if that were the case in closing, there was time for Judge Bakker to communicate with the prosecutor Koch, who then would communicate with the trial prosecutor. And of course, none of those were on email, so we didn't get them if they happened. All right, we can keep going. To start, the Sixth Circuit explained that an ex parte communication between the prosecutor and trial judge can only be justified and allowed by compelling state interest. And this is the case of United States versus Minsky. So let's keep going down. And they call this the Barnwell test. So we'll go to the next page. And here, he ends with saying, the email exchange occurred during live witness testimony in the midst of the defendant's trial, and they involve substantive matters associated with the defendant's trial. So what Justice Bernstein said is it was unfair for the Supreme Court to place the burden of showing actual bias on the judge, because in this case, they considered all the stuff that happened not evidence of actual bias, or that it had to affect the jury somehow. And how can a defendant show that? What Justice Bernstein said using the Barnwell case was that the burden of proof would be on the prosecutor's office to show that there was a compelling state interest in the ex parte communication, and if you couldn't show a compelling state interest, there had to be a new trial. And I think that is more equitable, and it puts the burden of proof on the person who violated the ethics rules.
Exactly, and that's just assuming that you even catch people violating the ethics rules, because keep in mind, they probably never realized that these were going to be subject to FOIA.
Yeah.
Because had there not been a FOIA, we wouldn't even be having this conversation. They would have gotten away with it.
Well, they did get away with it for years.
Yes.
And who knows how many other cases there are out there, and who knows how many other cases have been spoken between them on cell phones that aren't subject to FOIA or weren't. How many things have been discussed over lunch? So it's you have to prove actual bias when the people that are biased are not. They're acting in ways that bias doesn't become something that's a public knowledge.
Yeah, it's like, they're playing football, we're playing baseball. I mean,
Yep.
It's the two different games.
So James, let's put up the Myrene Cook's response, or her victory lap that she did.
Which, by the way, I don't have access to because Miss Cook or somebody associated with her blocked me, a fellow public servant, from her Facebook page. Maybe because, maybe Justice Welch, quoted or at least referenced our amicus.
And the amicus brief was a Watson Township on behalf of the entire township.
On behalf of the entire township, so she is now singled me out. I've never posted anything to her page, nor would I have. Now, if she pushed something, sponsored something, and it appeared on my page, I'd probably make a comment. But
Yeah.
I wouldn't go out of my way to.
I don't think you're the only person in this room that's been blocked.
Yeah, I know. I got blocked as well, but I was a little more vocal. But I didn't know the rules. I didn't know if elected officials can block you on the.
They're
I
not.
don't
They're
know.
not supposed to, but she's done it. She's done it to several people.
The other thing I think is funny. One of the things that you had brought up last election was the cost to the taxpayer, and now to think that this has gone to the Michigan Supreme Court, who are funded by all Michiganders' taxes, and if it has the potential to go to the United States Supreme Court, she might be literally costing every American.
Well, the thing that's funny is that she said that the FOIA creates a real big cost to the county. When you request FOIA, you have to pay for the information. You have to pay for the time to collect the information. You have to pay for the time to look for the information. So a person requesting FOIA actually pays for that. So she's wrong about that. But what is the cost of her and Marge Bakker communicating during a trial by email about the trial? How much did she cost the county by doing that? And is going to continue to cost the county, because this is going to go to the Sixth Circuit. It may go to the Supreme Court. Who knows? It's not over yet. And there may be impetus. I mean, I think some of the justices, if they feel like she has violated the canon of ethics and that Myrene Cook has violated the attorney code of judicial or code of professional conduct, they might have an obligation to start another investigation. So that's all at a cost to the taxpayers of Michigan.
And also the time, these judges' time in the Supreme Court is limited. They only can hear so many cases, and so their actions are costing everybody.
So let's put that back up, the Myrene statement. And I want you to think about this statement in light of what we just read. The email communications did not violate the defendant's constitutional right to a fair trial. Well, that's what the lead opinion concluded. So she's only citing a part of what they said. Further, the justices stated there was no evidence Prosecutor Koch shared any information with the trial prosecutor, because it was clear the trial strategy did not change from beginning to end. Justice Bernstein would disagree with it. There was no miscarriage of justice. Well, again, this is one of those things where if you want to say that a judge violated violated the canon of ethics, should have recused herself and didn't, that's not a miscarriage of justice.
I think this goes right back to what Judge Viviano said during oral arguments. He was afraid about opening the floodgate because there's literally enough evidence that was presented to the Supreme Court that some of the justices picked up on to show that there was actual bias by Judge Bakker toward Myrene Cook. And the court's three-person opinion that was joined in some part narrowed the focus to just the low case before them. To say, hey, well, in this case, maybe there's just not enough there.
They even said the appearance of biases does not conclusively prove actual bias.
But if there is actual bias, then he would be entitled to a new trial.
Right.
And I think some of the justices did pick up on that there was actual bias.
Well, today, there was a motion. As soon as the Supreme Court case came out, the prosecutor filed an emergency motion to revoke Daniel Lowe's bond and put him back in jail, or prison, actually. And that was heard by Judge Baillargeons, and I think it would be really instructive for us to listen to what Judge Baillargeons, now bear in mind, Judge Baillargeons is a fellow Allegan County judge. So let's play what he said.
All right, Mr. Lowe, you stand here convicted of a serious crime. In fact, I would characterize it as a heinous crime. And I don't know the facts or details of the crime that you've been accused of. And for that is not what these proceedings post-conviction have been addressing. What these years of appellate review have been exploring has been whether you should be entitled to another trial or the possibility of an evidentiary hearing to decide if the actions of Judge Bakker and Prosecutor Koch deprived you of the right to a fair trial by an impartial, unbiased judge. I do not say, nor have I ever stated, that you are not guilty. That's not my place. But my concern centered on this. Due to the extraordinary revelations of improper communication by Judge Bakker and Prosecutor Koch, you were in fact, or in appearance, deprived of the right to a fair trial. I maintain that every accused individual, from a former president of the United States to a local farmer, mailman, or grocery clerk, has the right to a trial presided over by a fair and unbiased judge. We in the Michigan One Court of Justice work hard to uphold that and all other judicial canons of ethics, as attorneys are to uphold the professional code of conduct. In this case, the actions of Judge Bakker and Prosecutor Koch were found by the Michigan Supreme Court to be unethical and lacking in integrity. The Supreme Court explicitly overruled and overturned the Court of Appeals opinion identifying the several ex parte communications between the two of them as administrative. And the Supreme Court explicitly stated these communications were an explicit breach of the judicial canon of ethics and by extension the professional code of conduct for attorneys. However, the court went on to find that this breach did not constitute constitutional infringement upon your right to a trial by a fair and impartial judge. The conviction was therefore affirmed. This court and every court in Allegan County, and in truth the entire state of Michigan, work hard to ensure each person that comes before the court is treated fairly and honorably. But to make no mistake about it, the behavior of Judge Bakker and Prosecutor Koch was found to be unethical by the Supreme Court. The actions of Judge Bakker and Prosecutor Koch have brought dishonor and shame to the courts of Allegan and perhaps to even the entire state. The damage done to public confidence is hard to measure, and the work to rebuild and maintain that confidence will no doubt be daunting, but that is what we swore to undertake when we took the oath to become a judge, as attorneys took the oath when they swore to enter into the bar. The Michigan Supreme Court indicated it would be appropriate to explore disciplinary measures apart from this proceeding, and in the name of preserving public trust and confidence in the judiciary's ability to police itself and attorneys practicing within it, I hope that significant consequences are imposed. At this time, I have no choice but to revoke bond and remand you to the custody of the Department of Corrections pursuant to the sentence imposed upon you by Judge Bakker. I hope that the stain upon the Allegan County Judiciary is washed away by the integrity, honor, and respect warranted by other judges within this county as well as the state of Michigan. We do our utmost to work to redeem, and we will do our most to work to redeem and restore that trust damaged by the actions of these two individuals. You are hereby, sir, remanded to the custody of the Allegan County Sheriff's Department.
All right,
Perfect.
that's good, James.
That was, first of all, Judge, salute. I'm glad that he is on the bench. I couldn't imagine anybody making that decision if their name was Elizabeth Peterson, who is the acolyte of Myrene Koch, and Judge Bakker coming to that same conclusion. That was the most brutal takedown, burn.
Well,
And maybe now would be another good time to bring up that reminder. This is what
right.
the response was.
There was no miscarriage of justice, and now the Court of Appeals and now the Michigan Supreme Court have given the vindication I've waited nearly 4 years for. And how she can read from what we've just witnessed.
Dishonor and shame were words that the judge used.
And you know, that I can't express how rare it is for a judge within your county to be able to say and speak the truth like that, it takes some courage, and it certainly will have fallout from what he said. But I think it's absolutely true. It's what he said was absolutely true. They should be, instead of touting their vindication, they should be ashamed and humiliated. They should be seeking forgiveness for what they did. And I have yet to hear any one of them ask for forgiveness or even acknowledge in the slightest that they did anything wrong. They're vindicated.
Well, I can tell you that I shared the words of Judge B to just about everybody I can, including staunch supporters of Myrene Koch, and they just responded, "Thank you for sharing this information."
And one of the things we're going to do is we're going to take, I posted the 9-minute, I posted the full hearing, but we're going to just clip out the portion that Judge Baillargeons was talking so that people can have that clip and share it. So I hope that I'll have that up tomorrow probably.
Yeah, because I mean, his words rang so true that there needs to be a healing process here, and it really begins with punishment, and it hasn't happened yet.
I don't know that I can talk about the punishment received by anybody or the results of the grievances that I filed, but I'm hoping that based on this, the Judicial Tenure Commission will reopen an investigation or open a new investigation based on the Supreme Court's, kind of brutal takedown of Judge Bakker. And then the same thing is true with Prosecutor Koch. I think that now that it has been determined conclusively that it was a violation of the judicial or the canon of ethics for the judicial canon of ethics, then it's clear that Prosecutor Koch assisted the judge in violating it.
Yeah, I mean, the legal community is the victim here.
Well, I think all of Allegan County is the victim.
That too. I mean, anybody that comes to that courtroom, yeah, it's.
Well, we've done a lot today. We've covered a lot today. Thank you for listening. I hope it didn't bore you, but it was pretty exciting stuff for us, and of course, exciting in a bad way. It's always a shame to have to look at things like this that show breakdown of the system, that show things that people should be ashamed of, and that they're not. So, we hope, and it's my hope, that you will vote for me on August 6th at the primary, because we're both Republicans. We're running the primary. And the first step we can do to stop this kind of behavior is to diselect Myrene Koch and elect me. So,
Amen.
Thank you for that. Thank you for your time, and we'll see you in the next podcast.